telling me, even if it proves to be true, that damaging a lining in the reflecting pool is something that Puro wants to prosecute to the full extent of the law, if it's proven true, and yet they're releasing people who pled guilty to assaulting a police officer? What freaking parallel universe did I just wake up in?
That was the response from North Carolina Senator Thom Tillis surrounding the arrest of an Olympian who is accused of damaging the reflecting pond. The water feature has been really the center of controversy after algae started blooming in it following renovations.
David Hearn, a former canoeist on Team USA during the 1992, 96, and 2000 Summer Olympics, says he didn't damage the pool and he was simply visiting the area.
I want to bring back in our chief legal analyst, Leif Rhodes. He said to reporters that he walked by the pool, wanted to check it out, dipped his hand into the pool, and then before we knew it, they had 2 National Guard troops come towards him, then the park police, and then he was handcuffed. Khalif, are you allowed to dip your hand in the reflecting pool?
According to his attorney, it's not a federal crime to touch water. So that's where I'll start. They're not charging him with touching the water. They're charging him with 18 U.S.C. 1361. This is the depredation against any property or the attempt to depredate any type of property. And that the courts have interpreted that extremely broad. It's not a bright line rule, but there are a couple examples of what that looks like. Spray painting federal buildings, attacking or vandalizing of vehicles, knocking down gates or fences, cutting down trees. I mean, those are clear examples, signs, fences. You don't have to permanently destroy. I mean, that's clear because if you spray paint something, it's not permanently destroyed. It can be painted over, it can be fixed. But there is nothing that gives us a hard, fast definition. But I would assume touching water wouldn't be it. I'd even assume if this hadn't been removed and you just touch the panels itself, I don't think that would be considered a depredation. I think there has to be some type of damage that would be inflicted. So a removing, a tearing, a pulling, a pushing, something to inflict damage, then I think you'd at the very minimum would have meet the definition of depredation.
Part of this Olympian's defense is there wasn't an intent to harm or cause damage, and the other is he's saying that he wasn't read his Miranda rights. Is that significant when you're handcuffed and arrested?
It depends on the time. I mean, prior to you making a statement, the officers have a duty to inform you of your rights. And so anything that you say after that obviously can't be used against you. But it depends on the time frame that he's saying, and did he make any statement at all? I mean, that's what I would want to know before I would be able to file some type of constitutional violation in a pretrial motion to stop this. But to Thom Tillis's point, there are other things that they could be going after other than this. I know that there is a point of emphasis right now to attempt to try to stop, this from occurring. But first of all, the intent portion, that's that willfully. So if you're not willfully doing it and you're accidentally doing it, if I stick my hand in the water, it happens to be a raised panel underneath there. I mean, there is absolutely no intent. And so what they would need, they as in the government, to be successful in this claim would be at least some type of evidence showing that he removed. And then you'd want to see some type of intent, text messages, emails saying, and I'm laughing because this is, I wholeheartedly agree with Thom Tillis that this is a lack of understanding of what this statute was intended to do. This was intended to stop rioters or protesters from destroying federal property. And so how could we do that during times like Vietnam War and things like that when people were trying to just, destroy property? You got guards standing there. It wasn't to protect swimming pools, or I should say reflecting pools. And not saying that you could not depredate that. I just don't think that this is the definition of what the intent, the legislative intent was trying to stop.
Is there any recourse for someone who's arrested in a high-profile case like this, even though the charges are minor in comparison to other things? Is there recourse for, or is it just, hey, sorry, charges are dropped, or can you maybe go back and say you defamed me? I don't know if this amounts to defamation.
Well, let's be clear. You could for sure, these may be light sounding, but it's a misdemeanor if it's less than 1,000. It's a felony if it's more than 1,000, up to 10 years in prison. And so if you can calculate the amount of depredation done to one little piece that was pulled off of the pool, and they could show that it was more than $1,000 in damages, yeah, he could be looking at up to 10 years in prison. So, yeah, while we laugh about it, this is serious to him. To the defamation aspect, no, but it would be a potential lawsuit for wrongful, prosecution, wrongful detention. He talked about being held for 5+ hours. I mean, those are the types of things where is that typically normal for you to arrest someone and not put them in front of someone to get a pre-trial condition for release, specifically for a non-violent crime like this? I'm not sure what their process looks like, but normally 5 hours for something like this, you would assume there would be a process where he'd at least be able to talk to his attorney, make a communication to his family. He said he had no phone calls, no anything during that time frame. So if it's ultimately dismissed, potential lawsuit down the road, not defamation, because this would be know that it was true at the time. That wouldn't meet the standard at all.
Okay. All right, Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.